Hello, I'm Chuck Todd, and welcome to Meet the Press Reports, where we choose a single topic in our news and politics and dive in deep. This episode, the dirtiest wrestling match you've ever seen. I'm talking, of course, about the fight over an opening on the U.S. Supreme Court. That's how it was described by NPR's Nina Totenberg, who you'll hear from in a moment. In the rare event of Supreme Court vacancies, we've grown accustomed to the political gamesmanship. Both sides of the aisle ready the party's talking points, their dire warnings, and increasingly their special interest fundraising arms. But if the stakes feel higher than ever, it might be because they are. The pressure on the court has mounted with every recent vacancy, heightened by the other two branches of government refusing, frankly, to do their job or compromise. And of course, by state legislatures who are passing bills on some of the most hotly debated cultural issues of our time. And Americans more distrusting of the other side than ever before. Yes, it's a lifetime appointment. Yes, it's the choice of a single person who occupies the White House. Yes, in recent years, the hearings are one of the few opportunities for ambitious United States senators to speak on live TV uninterrupted for hours on end. But was it always this political? Well, yes and no.
This is probably not about persuading each other unless something really dramatic happens. All Republicans will vote yes, and all Democrats will vote no.
The confirmation hearing as a high-stakes political brawl didn't start with Amy Coney Barrett.
What your political opponents want to paint you as is a TV or cartoon version of a religious radical, a so-called handmaid.
Yes, Judge, I think this hearing is a sham.
And it didn't start with Brett Kavanaugh.
You're out of order. I'll proceed.
We cannot possibly move forward, Mr. Chairman.
I extend a very warm welcome
to Judge Kavanaugh. We have not been given an opportunity to have a meaningful hearing on this nominee.
What you want to do is destroy this guy's life, hold this seat open, and hope you win in 2020. You've said that, not me.
It's screw your adversaries. Winning is a marvelous thing. Losing is not good. But now people don't want to win. They want to win, and then they want to rub the other guy's nose in
the partisan battle that played out before cameras during the Kavanaugh hearing was a culmination of decades of polarization of the Supreme Court nomination process. In 1954, Chief Justice Earl Warren brought a divided court together in a unanimous decision, Brown versus Board of Education, which banned segregated schools and gave birth to the modern civil rights movement. Segregationists campaigned to impeach Earl Warren.
What has he done that makes you think he should be impeached?
The Supreme Court is not only interpreting law, they're creating law which is unconstitutional.
In 1968, when Warren announced he was retiring, President Lyndon Johnson moved to elevate Abe Fortas to be Chief Justice.
Fortas was already on the court. He'd been on the court since 1965. But Republicans saw an opportunity to shut down that nomination process and hold that seat open in the hope that the Democrats would lose the White House in 1968, which in fact they did.
But the modern pitched confirmation battle began with Robert Bork's watershed defeat in 1987.
But it's with great pleasure and deep respect for his extraordinary abilities that I today announce my intention to nominate United States Court of Appeals Judge Robert H. Bork to be an Associate Justice of the Supreme Court.
Within an hour of the announcement, Senator Ted Kennedy went to the Senate floor and set the tone for the nomination process.
Robert Bork's America is a land in which women would be forced into back alley abortions, blacks would sit at segregated lunch counters.
Civil rights organizations, pro-abortion groups, and liberals are lining up tonight, prepared to fight President Reagan's nomination.
It became a campaign.
This is Gregory Peck. Robert Bork wants to be a Supreme Court justice, but the record shows that he has a strange idea of what justice is.
Bork was also his own worst enemy.
Robert Bork testified for 5 days. 5 days. He disdained doing any practice sessions at the White House. And it showed. I mean, he gave answers that were politically stupid.
Why do you want to be an Associate Justice of the United States Supreme Court?
I think it would be an intellectual feast just to be there. And
this is not what most people out there want to hear. They want to hear that this is an honor, that you want to do justice, that you care what people's lives are like, that you don't say, oh, it's good for me.
Bork was rejected by the Senate, 42-58.
Despite Bork's own liabilities and poor performance at his hearing, for conservatives, he became a symbol of liberal overreach and a verb, to Bork, to attack or defeat a nominee unfairly through an organized campaign of harsh public criticism. Chief among those conservative critics at the time, Kentucky Senator Mitch McConnell.
You happen to be the one who set the new Senate standard that will be applied, in my judgment, by a majority of the Senate prospectively.
And McConnell made a threat.
It is a formula for gridlock, but it is, after all, a bit of freedom for each of us to do our own thing. We may not be able to pick the nominee, but we can sure shoot them down. We can sure shoot them down.
Bork's failed nomination galvanized the Federalist Society, which had started as a group for conservative law students in 1982.
The Federalist Society, I think, filled an important void for conservatives when they needed somebody to counter what was the prevailing liberal ideology. And it started on campuses.
The battles become more intense, more pitched, and it's not a coincidence that during this period, you've seen the development of essentially a permanent infrastructure of organizations that exist. They lie in wait for one of these nominations to happen. And as soon as the nomination is put forward, the gears click into place and the machinery starts to move.
The Federalist Society was one of Clarence Thomas's chief defenders.
I felt that I had to tell the truth. I could not keep silent.
I would like to start by saying unequivocally, uncategorically, that I deny each and every single allegation against me today. This is a circus. It's a national disgrace.
And when Antonin Scalia, a conservative icon, died in 2016, and President Obama nominated Merrick Garland to the court.
Someone who brings to his work a spirit of decency, modesty, integrity, even-handedness, and excellence.
It was Senator Mitch McConnell who said hours after the death of Scalia that this vacancy should not be filled until we have a new president.
We're not giving lifetime appointments to this president on the way out the door to change the Supreme Court for the next 25 or 30 years.
The thing about McConnell is he's such a brilliant strategist.
In fact, Totenberg says some Republican senators wanted to give Garland a hearing. McConnell said no.
And he made it very clear to every one of those people that he would recruit and fund a primary opponent if they did that. And gone. I mean, they all just fell into line.
One of my proudest moments is when I looked at Barack Obama in the eye and I said, Mr. President, you will not fill this Supreme Court vacancy.
It's not even a war. It's the dirtiest wrestling match you've ever seen. And there are no rules anymore.
McConnell has reshaped the courts during the Trump era. According to the American Constitution Society, McConnell has confirmed 218 judges, including 53 on the circuit courts, among them Amy Coney Barrett.
Well, you don't get to write your own legacy, but I will say that what we're doing in the area of the courts, I think, is the most important thing we're doing.
Chief Justice John Roberts is one of the people who thinks the confirmation process is broken.
We don't work as Democrats or Republicans, and I think it's a very unfortunate perception that the public might get from the confirmation process.
Joining me now are some faces you saw in that piece, NPR legal affairs correspondent, none other than Nina Totenberg. Jeff Sheshel. He is author of Supreme Power, Franklin Roosevelt versus the Supreme Court. The senior editor of The Dispatch, David French, who waxes big time when it comes to the judiciary on his own podcast almost weekly. And Robert Tsai, professor of law at American University College of Law and author of Practical Equality, Forging Justice in a Divided Nation. All right, let's start with a simple premise here, and I want to get everybody's take. How did we get here? Eventually, I want to see how we can get out of this politicized version of Supreme Court nominations. But how did we get to this point where we've decided these open vacancies are battles to the death? Nina, you first.
Well, I don't think there's a simple answer to that question, except that by the time we have reached this moment, what you see is a pretty raw demonstration of political power. It may look like hypocrisy, it may be hypocrisy, but the Republicans have the votes, and they're going to use them.
David French, you've said at times that the more we fight over the judiciary, it is a reflection of how poorly Congress behaves.
Yeah, I mean, what we have right now is we have a situation where Congress is rarely passes significant legislation, rarely. And so what this does, I mean, a lot of people have complained about this, and rightfully so complained about this, that Congress doesn't act as its own independent institution, but rather each side of Congress is more like the partisan advocates for or against the president. But what's happened then is a lot of Americans, understanding the gridlock in Congress, have resorted to the courts. And so one of the advantages you have if you sue is that you actually will get an answer. You'll get an answer from the government. You'll get an answer from a judge. A judge will rule for or against you. You can appeal that. Then you can appeal that. And courts have become, in many ways, honestly, the most responsive branch of government, and people have acted accordingly, and that has increased the power and prominence of the courts.
You know, the irony, Jeff Shushel, is that, in fact, I think I've got some poll numbers I'm going to pop up here. Of all our three branches of government, right, Congress is enormously unpopular. Right now, this current president's very unpopular. I don't know if any president can get 60% popularity in this day and age generally. But the Supreme Court in July had an approval rating. This was before Justice Ginsburg's death. Overall, 70%. 75% of Republicans approved. 67% of Democrats approved. And it was some 60% of independents. I mean, ironically, it ended up being one of the sort of the most stablest institutions if you looked at it from a partisan perspective.
The Supreme Court is an incredibly resilient institution, and it probably helps that they get to put on those robes and close the doors. And most of the work they do very quietly. They are not talking at us. They are not tweeting at us. They are not part of our public life in a very active way. There's still a tremendous sense of mystery about the work that they're doing. And frankly, a lot of the work they do and indeed the damage that the Supreme Court does is not all that obvious to the American people. Some of these decisions are very straightforward in terms of what was decided and the effect it's going to have on people's lives. There are a lot of other Supreme Court cases, a lot of other opinions that have tremendous impact that are a lot harder to explain. And so there is still a veil, even in our world of constant communication.
Yeah, Robert Tsai, I do think the Supreme Court, I think when you look at those numbers, the right sees it because they feel like they've got their justices. The left is like, oh, look, John Roberts doesn't always work with them. It's like everybody finds what they like about the court. It's such an unusual situation because normally people always are looking for what they don't like about something.
I think that's right. I would just sort of pull on one of David's comments about popular sort of reliance on the court and say that I think that in order to understand the intensity today over a vacancy on the Supreme Court, we have to be able to understand some broader trends. And one of those trends is how a lot of people, ordinary people, but also the parties themselves, the two major parties, have become incredibly reliant on the courts to entrench their own policies over time. And so certainly with the Warren Court, we saw liberals becoming much more interested in turning to the courts, progressives turning to the courts to try to get rights expanded and written into law. But there was a time when conservatives tried to hold the line by talking about judicial restraint. But what we've seen is modern conservatives have actually switched and joined with the strategies of legal liberalism. They joined the liberals insofar as they see now great value in relying on the courts to get their things done. So instead of decrying judicial review, they're demanding that certain rights be expanded, gun rights be expanded, the rights of corporations to speak be expanded, religious groups' rights to be expanded to the extent that they can be free from civil rights laws. So I think that is a huge kind of sea change in kind of conservatives buying into this dependency on the courts.
You see it in campaigns right now. Both parties care a lot more about the elections of state attorney generals attorneys general than they ever have before. And I think many of it see it as a way to fast track of how to get to a court, if they can get their AGs in line, whatever side we're talking about. Let me go to the confirmation process. Nita Totenberg, you said something interesting in our piece about Judge Bork. And you had Bork was his own worst enemy when it came to the hearings themselves. And there's something about those hearings that I think give us now the frustration that we watch today in confirmation hearings. Judge Bork talked too much. And every other nominee that came after him realized that and never said a word again. I mean, is that what we have to blame for our sort of opaque nature of confirmation hearings going forward?
Well, it's true that the judicial candidates of both parties have been increasingly obtuse in their answers and simply resistant to answer. But with each nomination, it seems to get worse. So if you go back and you read actually the Ginsburg hearings, she answered way more questions than one would think. And she was very forthright about the fact that she thought that under the Constitution and the Equal Protection Guarantee, women had the right to control their own reproductive destiny. So she even answered a question about Indian rights. I was just astonished. But now, and I would have to say in the last 4 or 5 nominations, probably half of them Democratic and half of them Republican nominees, these nominees really are trained to say nothing. And Senator Durbin on Thursday said, I don't really know what the purpose of these hearings are anymore if I can't even get an answer about whether climate change exists.
David French, you're an intellectual combatant, meaning you love intellectual debates. I got to think these confirmation hearings for someone like you who loves the sort of this ideological discussion when it comes to sort of judicial philosophy and things like that, we learn very little from these hearings, and it is getting worse and worse.
No,
how can we fix it?
It is getting worse. It is getting worse, and it's even worse than the hearings, because what's happening is there's also the creation of what you might call a judicial career track on the right, where somebody is going to essentially qualify themselves by their associations and their academic credentials, but their actual writings and expressions of opinions are going to be studiously limited to an awful lot of more analysis than expression of philosophy, if that makes sense. And so, I think one of the ways that we're going to have to end up fixing this is somebody's got to go first. There's got to be a nominee who just engages in the back and forth and prevails, sort of the reverse Bork. And I think that, precedents matter, and each precedent seems to deepen and cement itself more. So I think that it's exactly right that each nominee is sort of less forthcoming. Somebody's got to go first. Somebody's got to get up there and say, yeah, let's talk about the Equal Protection Clause. Let's have that discussion and win. And that could change things perhaps a bit.
Jeff, my big concern about the court is that as we create these vetting groups who then do what David described, it's like they look at the people that be the most likely picks and just say, hey, be careful here, be careful what you write, sort of prepare yourself to be a potential nominee so that you have as thin of a potential resume for Oppo research as possible, is you end up getting a sameness in your court nominees. They may be ideologically different, but their life experience is awfully similar. We don't get different kinds of people on the court anymore. They're in some ways very similar. They may have, again, ideological differences, but they went through the same law schools and the same this and the same that, just from different perspectives. That's not a rich life to understand American culture.
It's not a particularly representative court. It's very representative of Harvard Law School and a VL Law School, and it's very representative increasingly of the Federalist Society. But you're absolutely right that there are other perspectives. I mean, Justice Breyer has brought to the court a perspective from actually having worked on Capitol Hill and actually having grappled with administrative law from another angle. That has really affected in a significant way many of the decisions that he has delivered over the course of years. But when you have young justices who come up through the machinery that David described of the Federalist Society and going to the right law schools and going to the right meetings and joining the right clubs, then there is a sameness, and it's particularly pronounced on the right, really because the machinery is more effective. It's better developed, it's better funded, and it gets better results.
Right.
From the perspective
Nina,
of those who
jump
want
in.
to know what decisions are going to come down.
Yeah. You wanted to chime in?
I was just going to say that what's so remarkable is, up until I'd say the Reagan administration, presidents didn't pick judicial nominees mainly from the lower courts. They weren't looking for guaranteed results. They had an overarching view. In FDR's case, he wanted the legislation that he had gotten passed to get us out of the Great Depression. He wanted it upheld because the court in previous years had struck down a lot of the big bills that had gotten passed, and that eventually changed. But by and large, the people who were selected for the court had a very wide diversity of experience, and they weren't plucked from the lower courts. Now, it's almost without exception, they are. And that leads to a sameness in itself. And if you want to go back to the early lives of the justices, the ones who are the most diverse probably were Ruth Bader Ginsburg and Sonia Sotomayor and Clarence Thomas, who didn't come up in a sort of middle to upper middle class upbringing and plan on exactly what every track would be. But with it's not just that the process has changed; it's the selection process has changed, and the camps have changed, because now we have two very clear camps: Republican, Democrat, liberal, conservative. And I would argue, I think that the conservative camp is probably more conservative than the liberals are right now, liberal, but that won't last forever.
No, that's for sure. I'll tell you, one of my pet peeves is that I think one of the 9 ought to be someone that has run for office before. And we haven't had somebody like that since Sandra Day O'Connor, who was the last person on the court who had actually faced voters. And I'm a big believer that you need some of that. Robert Tsai, let's talk about judicial reform. Is expanding the Supreme Court realistic? Is that something that would serve as a reform, or is that a political solution to a political problem? Is term limits a better idea?
Well, I think, broadly speaking, reform of the courts and reform of the Supreme Court has to be on the table. And, this is something that has been a long time in coming. So I'm happy that there are a lot of people who are now talking about this. I think part of the flip side of a lot of people coming to generally rely on the courts and feel good about the courts generally is that they don't have to pay a lot of attention to the sort of swings in kind of ideological views that actually can have a huge impact on people's everyday rights.
And I know that everybody has a strong opinion on those, but that is the point of this. We want to lay it out and let people absorb this, and we'll discuss more of that down the road. Nina Totenberg, Jeff Sheshel, Robert Tsai, David French, thank you all. I hope we have at least laid this out and helped people understand how the heck we got here. Up ahead, why I'm obsessed with the positives of negatives and the negatives of positives. Finally, I'm obsessed with the bottom line, one that's usually pretty difficult to see.
In all reality, we know that these polls are within the margin of error.
Within the margin of error.
Within the margin of error. Within the margin of error. The margin of error. Within the margin of error.
Margin of error. The giant asterisk of election polling. In teeny tiny little type. The great crutch of journalists who don't know much about polling. It's often spoken of, but rarely understood. So let's break it down in plain English. The margin of error is essentially a small percentage that assumes a potential miscalculation in polling. It allows for the possibility that the poll numbers may be slightly different than reality, in one direction or the other. But here's what you really need to know. Let's say a candidate gets 48% of voter support in a poll with a margin of error of 3.5%. That means his or her number could really be as low as 44.5% or as high as 51.5%. But it's not an equal chance. It's just a possibility. That's what the 3.5 points in either direction means. In other words, practically speaking, there's a pretty big margin of error in the margin of error. You have to double it, but even then, with a caveat. Now let's say candidate A is 48% support and candidate B is 42% support. Is that a tied race? The potential swing of each of those numbers could be 7%. And that means there is a slim possibility that candidate B is actually ahead. But that's a big if. Still, it is an if, one that you can't ignore. And that begs the question. If the margin of error could have such a significant impact on how a poll is read, why is it always in that miniature font, hidden in plain view at the bottom of the poll, forgotten and dispensed with like so much rubbish? Like the rapid-fire side effects in a pharmaceutical ad?
Side effects of Marginex may include diminished sample size, random polling, non-responsiveness, question loading, statistical averageness, electile dysfunction, and lactose intolerance.
Really, we need to rethink the margin of error entirely to factor in all of the variables that we've mentioned earlier. Not just who gets polled, but how they get polled. Polls with better data should have lower margins of error, right? And let's be sure to put it in a font size where we can actually all see it and read it and get it. Or if we can't spare the space, at the very least, then slap on a warning label. That's all we have for Meet the Press Reports. Join us next time when we may actually know who won the presidential election and who didn't. So we're actually going to take an in-depth look at the art and the impact of the concession speech, how candidates can lose and still win. Hey, thanks for being with us. I'll see you Sunday on Meet the Press. Hey, thanks for watching our YouTube channel. Follow today's top stories and breaking news by downloading the NBC News app.